welcome back to the channel Legal Ease. Today we will be discussing about the concept of res judicata, which is a very important concept under CPC, and it is similar to the concept of double jeopardy under the criminal law. So without wasting much time, let's move to this particular concept of res judicata. The res judicata concept is mentioned under section 11 of CPC, and it has multiple objectives and the maxims on which it is based. So first move on to the objectives and the maxims. So the intention behind this principle is that no person should be vexed twice for the same cause of action. That is the meaning of this particular maxim as well. No person shall be vexed, or any judgment should not be given against one person two times, or should not be tried two times for the same thing, for the same act for which a decision has already been passed. Second is that state has an interest in putting an end to the litigation. That means a litigation should come to an end. That is also in the interest of the state. Third is that res judicata pro veritate occiputur means that the decision should be accepted as final once it is passed by a court competent to try it. So if a decision is given by a competent court, the decision should be accepted by the parties. The reason why these maxims are there, the reason why this principle is there is that whenever a case is tried, it invests both time and money of the court, the whole judicial delivery system, and justice delivery system, as well as the people who are the parties to the suit. So when time and money is invested by those people, uh, the whole justice delivery system and the people involved in it and the parties, it is reasonable to stop the wastage of time and money again on the same thing, and that is why this particular principle has been incorporated in the laws, both criminal and civil law. Under the civil law, it is covered under section 11 of CPC. So let's move to the language of section 11. This is the body of section 11, which also has 8 explanations within it. First, we will understand the body and then we will move on to the explanations. So it says, or it start with no court shall try. So यहाँ पे जो restriction है, it is on all the courts, because it is saying no court and nothing is written related to the which court, where the court should be situated or anything. That means all the courts are barred under res judicata to try a matter. Try मतलब यहाँ पे the court cannot even start a trial. That means कभी भी कोर्ट के पास अगर कोई प्लेंट आती है तो कोर्ट will say sorry, we cannot try this particular matter if it has already been decided by the court. We'll see what are the requirements. If all these requirements are fulfilled, then any court in India will be stopped or barred from trying a particular matter wherein either a suit or issue has been decided. So यहाँ पे we will see the court is barred from trying any suit or any issue in which a matter is directly and substantially in issue in a former suit. Okay, so that matter should be directly and substantially issue in the former suit which has been decided and has come again in the subsequent suit. The matter should be between the same parties or between the parties under whom they or any of them claim. They should be litigating under the same title in a court competent to try the suit. Competency also should be there in both the suits, in which such issue has been subsequently raised and heard and finally decided by such court. So these are some of the terms that need to be interpreted to understand the application of res judicata under section 11. So we'll understand the meaning of each and every term one by one. Let's start with the term suit or issue. So it says no court shall try any suit or issue. When we talk about the suit, it means the whole suit is barred. That means, let's suppose there is a suit between A versus B, and there are 3 issues, 1, 2, and 3, and the court has decided on all these 3 issues. That means the whole suit was decided in favor of A. Again, a suit is filed between A versus B, and the issues which were involved by A are 1, 4, and 5. So this whole suit is not similar, only the one issue is similar and the 2 issues are different. In this particular case, even if one issue is same, this particular issue will be barred by res judicata and the court can move ahead with the 4th and 5th issue. ठीक है, अगर इस सब्सिक्वेंट सूट में भी 1, 2 एंड 3 इशू होते तो ये पूरा का पूरा सूट बार हो जाता, लेकिन यहाँ पे क्योंकि पूरा का पूरा इशू सेम नहीं है, ओनली वन ऑफ द इशू इज सेम, सो दिस इशू विल बी बार्ड एंड द रिमेनिंग इशू विल कंटिन्यू। जैसे अगर एक केस है जिसके अंदर द इन द फर्स्ट सूट द डिस्प्यूट the issue is related to the ownership as well as the possession over the property. The court has decided in favor of A that he is the owner and should get the possession of the property. And the subsequent suit is for the possession and the means mesne profits. Then in those cases, the court will bar at least this particular issue because it has already been decided in this former suit. So subsequently, this suit will be barred. The other suit or other issue can continue provided all the other conditions are also fulfilled. So we will see the other conditions and then we will decide whether the subsequent suit will continue or not. But for this particular requirement, at least possession will be barred because it is the same issue, if not the same suit. Coming to the next requirement, that is the same parties or under whom they claim. So again, same parties means if there is a suit between A and B, then B versus A is the same party. If there is a suit between A and B versus C, then A versus C, B versus C, or C versus A, or and B, C versus A, C versus B. All these suits will be barred if the other requirements are fulfilled. So these all are barred under the concept of same parties. Or under whom they claim includes, again, let's say A versus B suit was there in which a decision was given in favor of A. After the death of A, let's suppose a property of A transferred in the name of the son of A. Later on, B cannot file a suit against son of A on the same property which was decided by the court in favor of A, stating that the party has changed. Now it is not A, it is the son of A. The court will say that now the person against whom you have filed the suit is claiming through the same party in favor of whom the suit has already been decided. So now son of A is claiming his right through A. He has got his right through A being a legal heir of A, and that is why B will be barred from filing the same suit against the son of A because it will come under the parties under whom they are claiming. So the same parties will be barred on the concept of same parties or parties under whom they claim. Coming to the next requirement, litigating under the same title. So here we will see whether the title of the parties are same or not. So for that, the title of the party is basically the legal capacity in which the party has filed a particular suit. So legal capacity can be same and can be different. For example, if in a suit between A and B, A is claiming his title as an owner over the property, uh, and in against B, calling B as a trespasser. Again, so in this particular case, they are under the capacity of owner and the trespasser. Later on, again, if A file a suit against B in the considering himself as an owner and B is a trespasser, this means that they are under the same title. But let's say earlier, in reference to a particular property, A had the lease over of the property. So here A was the lessee of the property and B again is a trespasser. Now he filed a suit against B for the purpose of trespassing as in the capacity of the lessee and the B as a trespasser. Later on, so in this case, the court decided in favor of B or A, whatever the court decision is, that is immaterial. The same issue related to the trespassing of the property by B is raised by A after he has bought the property and now he has got the ownership over the property. So now in the subsequent suit, when he is filing the suit against B, who is a trespasser, he is filing in the capacity of the owner and not as a lessee. So in the first suit, the capacity was of that of lessee, which has a limited right, and in the second suit, he is filing a suit on the capacity of a owner, which has broader rights. So these two suits will not be barred by res judicata because यहाँ पे title different हो गया. So the title should also be the same. There are a lot of examples related to the same title. If you want me to explain about it more or discuss more examples, please comment it in the comment box. I will include more examples and I'll make a separate video on this same title and the different titles and the examples related to it. Coming to the next point, that is matters directly and substantially in issue and the matters collaterally and incidentally in issue. When we talk about matters directly and substantially in issue, that means the matter should be same which were necessary to decide a particular claim and decide whether the relief should be given to the parties or not. For example, if a person, if let's suppose again the plaintiff want possession over a property, so any matter which any issue which decides on the question whether the plaintiff should get the possession over the property or not is a matter directly and substantially in issue. And if a particular matter is decided which is not directly answering the question of possession, whether a plaintiff should get the possession or not, is a matter which is collaterally and incidentally in issue. Uske liye again, let me take an example of a matter which is collaterally and incidentally an issue. Let's suppose there is a property, and again, we'll take the favorite names of the parties A and B. So, A is the lessor of the property, B is the lessee of the property. B is also the owner of a property adjacent to it. ये property A की है, ये property B की है. ये जो property है जिसको मैंने अभी ऐसे शेड किया है, this particular property is the property of A which has been given on lease to B. ठीक है? A suit is filed by A against B for the arrears of rent that B has not paid the rent to A, and the court decided that particular matter. While deciding that particular matter, the court also said that this particular property, which I have shaded in this way, crossed line say, this particular property also belongs to A. Okay? The matter was whether the rent is due, whether B is a tenant over this shaded part of the property. Let's say इस shaded part को हम बोलते हैं X part of the property और ये different तरीके से shaded है इसको हम Y part of the property. So courts, the dispute was related to this X part of the property. While deciding that dispute, the court also said that this Y part of the property does not belong to B but belongs to A. लेकिन इस बारे में कोई क्वेश्चन ही रेज हुआ था कि यहाँ पे इससे रिलेटेड कोई रेंट अग्रीमेंट है या नहीं, इससे रिलेटेड कोई पोजेशन का केस है या नहीं, या इससे रिलेटेड ही इज आस्किंग फॉर अरियर्स और एनीथिंग. देयर इज नथिंग रिलेटेड टू दिस पर्टिकुलर पार्ट ऑफ द प्रॉपर्टी. ओनली दिस पार्ट ऑफ द प्रॉपर्टी वाज इन क्वेश्चन. But the court said that this property belongs to A. This Y property belongs to A. Now, this has been decided, and the court said that B has to give certain amount as arrears to A. So this case has been decided. Subsequent suit is filed again by A against B, claiming here in this subsequent suit, A is claiming possession for that Y part of the property. Now, let's say not A, B is claiming. That will make this suit better. B is claiming that I am the owner of this Y part of the property and I should be given the possession of the property. क्योंकि इस judgment के बाद से A ने इस particular part पे possession ले लिया था. A claims in the court that this particular issue has already been decided by the court. Court ने बोला था that this Y part of the property is mine, that is of A, and that's why this is in my possession. And the suit before the other court is barred by res judicata. Now the court will decide that it is between the same parties, the matter, but whether it is directly and substantially an issue in the previous suit or it was collaterally and incidentally an issue in the previous suit. To decide the question of arrears of rent, it was not necessary to determine the Y part of the property क्योंकि arrears सिर्फ X part of the property से related थे. यहाँ पे जब सिर्फ X part of the property से related थे, but कोर्ट ने अगर Y के बारे में भी बोला तो ये जो इशू है Y से related, ये directly और substantially इशू में नहीं था क्योंकि Y part को determine करना जरूरी नहीं था to determine the relief which was claimed by A. जब ये जरूरी नहीं था तो ये collaterally और incidentally an issue हुआ. और जब ये collaterally और incidentally an issue है, ये issue will not bar a subsequent suit. और जब ये बार नहीं करेगा, दैट मीन्स बी कैन फाइल अ सूट अगेंस्ट ए claiming ownership over this Y part of the property, and the court can again decide whether this property belongs to A or B. तो यहाँ पे because the property was collaterally and incidentally an issue and not directly and substantially an issue, it will be barred. Sorry, it will not be barred by res judicata. And otherwise, अगर ये directly और substantially an issue में होती तो वो बार हो जाती. I hope this is clear. Again, if not, please ask your doubts in the comment and I can make a separate video on it. Coming to the next requirement, former and subsequent suit. So there is a requirement of two suits. One should be a former suit, one should be a subsequent suit. How will you determine which suit is former and which suit is subsequent? So explanation one is also provide or gives details about which suit is a former and which suit is a subsequent suit, but it will be decided on the basis of the date of decision of the court and not on the basis of the date of institution of the suit. So let's suppose a suit was instituted in the year 2020 and is still going on till 2024, and a suit which was filed in 2022 was decided in 2023, and all the requirements are met between the same parties, matter directly and substantially in issue, the whole suit, all the issues are same. If all these requirements are met, then this particular suit which was filed in 2022 will be the former suit, and the suit which was filed in 2020 will be the subsequent suit because the decision was given in this suit earlier than this particular suit. तो चाहे ये पहले फाइल हुआ हो, it will not be a former suit because the decision came subsequent or decision came later or did not come till the time the decision of this particular suit came. So former and subsequent suit will be determined on the basis of the date of decision of the case, not on the basis of the decision or institution of the suit. Coming to the next point, heard and finally decided. Heard and finally decided on the basis that the decision has been given by the competent court. So if the suit was filed in a trial court, then if the trial court has given a decision, that decision will be final irrespective of the point that it can be appealed or not. अगर अपील हो सकती है तो भी वो फाइनल डिसीजन है, अपील नहीं हो सकती तो भी वो फाइनल डिसीजन है. तो अपील फाइल हो सकती है नहीं हो सकती, उससे हम किसी डिसीजन को ये नहीं मानेंगे कि वो फाइनल है या नहीं. लेकिन बाय चांस अगर अपील फाइल हो गई और उस अपीलेट कोर्ट ने इस डिसीजन पे स्टे लगा दिया, तो स्टे लगने के बाद द डिसीजन विल नॉट बी कंसिडर्ड एज फाइनल, और फिर अपीलेट कोर्ट जो भी डिसीजन देगी दैट डिसीजन विल बी फाइनल. तो ट्रायल कोर्ट का डिसीजन फाइनल होता है टिल द टाइम अ स्टे इज पुट इफ अपील इज फाइल्ड एंड द अपीलेट कोर्ट हैज पुट अ स्टे ऑन. अगर स्टे नहीं लग रहा है या अपील फाइल नहीं हुई है या अपील फाइल हो सकती है बट अभी तक या अपील फाइल करने का टाइम पीरियड खत्म हो गया है, वॉट एवर द रीजन इज, द डिसीजन विल बी final of the trial court and the res judicata will be applicable as per the decision of the trial court. ठीक है. अपील अगर फाइल होने के बाद स्टे लगा है तो ही ये डिसीजन फाइनल नहीं होगा. सो प्लीज ऑलवेज रिमेंबर द ट्रायल कोर्ट डिसीजन इज ऑलवेज कंसिडर्ड एज हर्ड एंड फाइनली डिसाइडेड अगर डिग्री पास हो गई है. लेकिन अगर जस्ट बिकॉज उसमें अपील फाइल हो सकती है 30 डेज में, तो आप ये नहीं बोलोगे कि क्योंकि अभी अपील के चांसेस हैं तो आप इस डिसीजन तो ये डिसीजन फाइनल नहीं है. अपील के चांसेस हो, लेकिन जब तक अपील फाइल नहीं हुई है और स्टे नहीं लगा है तब तक वो डिसीजन फाइनल ही होगा irrespective of anything. So this you have to consider while going into the question whether a suit has been heard and finally decided. Coming to the next requirement, that is of the competency of the court. So the court should be competent, both the former and the subsequent. So this is also one of the exception to the rule of res judicata, that if the former suit or the former court which has decided the suit, obviously the decision which came earlier was an incompetent court. Incompetent matlab the court did not have the jurisdiction. Any type of jurisdiction can be there, either the territorial jurisdiction or subject matter jurisdiction or pecuniary jurisdiction. कोई सी भी अगर jurisdiction नहीं थी इस former court की और फिर उन्होंने decide कर दिया So this decision will not bar the subsequent court from deciding on the same matter. ठीक है, क्योंकि जो पहला डिसीजन था वही वैलिड नहीं था। लेकिन अगर फॉर्मर कोर्ट कॉम्पिटेंट थी और सब्सिक्वेंट भी चाहे फिर कॉम्पिटेंट कोर्ट ही क्यों ना हो, इट विल बी बार्ड। तो सब्सिक्वेंट कोर्ट कॉम्पिटेंट, फर्स्ट ऑफ ऑल दोनों कोर्ट कॉम्पिटेंट होनी चाहिए, and then the subsequent will be barred. If the subsequent court is not competent, then there is no question of application of res judicata, क्योंकि subsequent court any which ways is barred because it does not have the jurisdiction. ठीक है, तो जब इसके पास जुरिस्डिक्शन है तभी हम सेक्शन 11 को लाएंगे, क्योंकि हम देखेंगे कि जुरिस्डिक्शन के बाद भी वो बार्ड है, क्योंकि पहले किसी कोर्ट ने ये मैटर डिसाइड कर लिया था विच वाज आल्सो अ कॉम्पिटेंट कोर्ट। ठीक है, दिस इज अ जनरल रूल, देयर इज एन एक्सेप्शन गिवन टू दिस पर्टिकुलर रूल इन एक्सप्लेनेशन 8 of section 11. So all the explanations of section 11 and the concept of constructive res judicata we'll discuss in the next class. I hope all the points related to the main definition are clear to all of you and there is no doubt. If there is, please mention it in the comment box and I will surely try to solve your doubts. So till that time, will please like and subscribe my video, comment on it, and thank you. We'll meet again with the constructive res judicata in the next video.